recording?
Yes.
Good. Is there a motion to adopt last month's minutes? Okay. Okay, so with 3 abstentions, 3 months. How many people here altogether?
There were 4 abstentions.
8 people.
Minutes to adopt.
5.
9.
9, okay. So that works. First item on the agenda is an amendment to the buildings department's penalty schedule.
Good morning, everybody. I'm Helen Goldberg, Deputy General Counsel for Oath. We have 1 proposed rule and 2 final rules for approval today. The first is a proposed rule which is based on a proposal that buildings made back in April concerning adding 5 new charges to the DOB schedule relating to construction superintendents. Do we have any questions?
Is there a motion? All those in favor? Okay, it's unanimous. Is one abstention? Hilda? The next item?
The next item is what we have been calling the model rules. These are, there is a repeal and reenactment of Chapter 3, which was the ECB rules. Most of those rules we have moved into Chapter 6, which will be the hearings division rules, and we are asking the board to approve the move of those rules from 3 to 6. What was unique to ECB remains in Chapter 3. We have, at the board's request, preserved the appeals panels. From the proposed rule to the final rule after the public hearing, there have been 6 changes. In 4 places, we changed board to tribunal for further clarity. The most important one, I guess, for me to point out is that we added a definition of oath hearings division to Chapter 6, which would include not only the former health tribunal and the former tax and limousine tribunal, but also the former ECB tribunal, although ECB as an entity still exists. And then we also defined tribunal and said that that's the hearings division. Also on section 613E, we added only, this is concerning motions to amend, so we wanted to clarify that there must be a motion to amend. ALJs, hearing officers will not be able to amend on their own motion. Any questions? Yes?
Just procedural, when we add things like that, does that then require like a new hearing or a new publication or
These are-
a new process?
That would be the law department's call. They have certified these changes and have not asked us to hold a new public hearing.
Thank you.
Law department basically certifies that the action is or is not ultra-virus.
Elizabeth Mountler, citizen member. I just, and I apologize that I wasn't here at the last meeting. I think this might have been discussed. I just wanted to hear from buildings as to whether their concerns in their comments have been addressed by the
Change. Yes. The Department of Buildings is okay with things as is, and all of our concerns have been addressed.
Anything else? Is there a motion? There's a motion. All those in favor, please signify. It's unanimous. The next item.
Next item on the agenda is a final rule, which is for the repeal of the air code penalty schedule, which is at this moment picture letters, the ECD air code penalty schedule, and for an amendment to section 3-100 of chapter 3, title 48, instructing the hearing officers to follow penalty schedules contained in agency rules if there is no penalty schedule contained in ECD's rules.
Question?
I have been opposed to all of these, just for the record, I will state my opposition to it. I think it's a bad government initiative. I think it takes one level of transparency out of the process, and that is the review by the few citizen members that are here on this board. It allows the agencies to make their own rules without any public oversight, and I'm opposed to it. I also, last time, as you know, we walked out when my motion to table such the previous attempt to repeal some rules was ignored. So I will not be making a motion to table this, because I know what the result will be. But I remind the members that you do not have to second it or make a motion for it. If it's not before us, we don't have to vote on it.
I would just point out from DEP's standpoint, because this is our penalty schedule, that if this penalty schedule is not repealed, then we do have a situation where there are two air code penalty schedules in the rules, because we have promulgated the new one and the new one has taken effect. So if the old one were to not be repealed, we would have two penalty schedules, which when people search for an air code penalty schedule, if they find the wrong one, or if they find both of them, could result in some confusion. Although I think it's understood which ones the hearing officers are applying. Just in general, to have two penalty schedules in the rules for the same code is not obviously an ideal situation.
Well, let me ask you, when DEP adopted that schedule, did they follow CAPA? The civil
The new
administration?
penalty schedule?
Yeah.
Yes, the new penalty schedule is in effect as of May 11th.
Was there a public hearing where the public could
There was a
come?
public hearing, yes, and there were no comments that I can remember.
And was there an opportunity for the public to submit written or oral comments?
It was published and promulgated in full compliance with CAPA procedure.
And did the commissioner review the results of those hearings or whatever comments came or didn't come? And-
Again, to my recollection, there were no comments to review.
And she signed the promulgation that was published in the city record?
Yes, it was published in the city record, and all of the CAPA requirements were complied with.
Thank you.
Question? Is my understanding, Ernest Cavallo, citizen member, my understanding that there was supposed to be a simultaneous repeal and then the institution of the new rules. Was I misled or am I mistaken?
It didn't happen.
But it was supposed to happen.
It was supposed to, and to be perfectly honest, the delays in the law department.
And yet,
I think then the confusion is not our issue.
Well, to the extent that the current penalty in the ECD rules contains incorrect penalties. There are penalties that are too high or too low based on the new air code. And I think that is an issue because we're materially misleading the public.
the air code is in the administrative code.
Right, but the penalty,
Right.
the ECD, hopefully former ECD penalty schedule is still in ECD's rules.
Okay.
Elizabeth Nauer, citizen member, I think that Bernie's frustration, which I share, is that now we're sort of put in a position that if we don't approve this, there is this confusion which nobody wants, and I think that's unfortunate that the policy of removing penalty schedules from ECB review has, it, by virtue of the enactment of, or the promulgation of the new air code penalty schedule in the DEP rules, we're now forced into the position that we can't really judge that policy. It's just an issue of whether we're going to have two penalty schedules or not. So I just wanted to voice that my vote or abstention, I'm still thinking about it, is based on the facts as of now and not the overall policy. Because I do think that while CAPA is an important process, that what I've seen from the CAPA review, the CAPA comments that have come in on rules that we've adopted, there are very few comments. It doesn't seem like the general public really is aware of these public hearings. The comments usually come from large, if at all, from large companies or organizations that have multiple issues before ECB. But where I in the past have objected to certain penalties, it has been the imposition of really high penalties on individuals. And I feel like there's nobody really to speak up for those individuals who, are pretty much hypothetical at the point in time where a rule is enacted or promulgated. So I just wanted to speak my piece. And that's it.
Thank you.
Question. Statutory, if there's two conflicting penalties, doesn't the law require you to institute the lower of the two?
It would more logically require the institution of the most recent of the two.
That's another issue. Okay, that'll be another issue.
And I would also say the legal penalty, because
Sorry, what do you
I would
mean by
also say the
that?
current legal penalty, some of the penalties in the ECD air code penalty schedule.
A statutory. It's a statutory base.
No, well, they're
Well,
they're
the
too
old-
high. The penalties changed. So some of the penalties in the ECB penalty schedule are too high or too low, based on the new statutory range in the current air code.
That's what I meant by statutory.
Yeah, I'm sorry.
And just again, Russell Pecunias with DEP, the existing, the schedule that still exists in Oath's rules does not match the new code. The numbering does not match, the statutory ranges don't match. There are many new provisions in the new code that are not in the old penalty schedule. So the penalty schedule that's in Oath's rules does not match the now current code really at all.
Thank you.
Doug Swan, citizen member. I just wanted to, say that, for the record, I concur with Ernie and Elizabeth. And I think the CAPA process does allow the public to have representation, but again, as we have seen, those hearings are, the comments are very few. And I think what the board provides here on a month-to-month basis allows true representation for the public. And I would hate to see that, or it's unfortunate that that's going away.
Anything else? Anyone else? Is there a motion? Second. All those in favor? 1, 2, 3, 4, 5, 6, 7. Those opposed? 2. 2, right? Abstained? 1. Motion carries. Thank you.
Thank you.
And I believe the next item on our agenda is a DEP request for cease and desist order.
Again, Russell Kukunis with DEP Legal. So this month, the Department of Environmental Protection is asking the board to approve cease and desist orders on a total of 54 requests involving failure to install backflow prevention devices. There are 25 that were dated from the May meeting and 29 that are dated for today, if I counted these correctly. In each of these cases, the building owner has been ordered to install backflow prevention devices at their building. They have failed to do so. They have been issued a summons for not doing so, which has been adjudicated in violation, and they are still not in compliance. So in each of these 54 cases, DEP is asking the board to approve an order to cease and desist.
Is there a motion? I think it's unanimous with one abstention. Which is DEP.
All right, and now, under the noise code, DEP is requesting 3 cease and desist orders. The first one, which is being brought back from the May meeting, although the cover memo was redated for today, involves Dell's Maraschino Cherries Company at 175 Dyckman Street in Brooklyn. This is a company that makes maraschino cherries. They are, according to conversations that I've had with the complainants, apparently not connected to Con Edison Power for some reason, and they run this facility off of a very large generator, a Caterpillar generator, of which there is a picture in the submission. This generator has been cited for creating unreasonable noise on 4 occasions, dating back to July of last year, and they have not corrected the condition. And due to the continuing failure to correct the excessive noise from the generator, DEP is asking for an order to cease and desist.
Any questions? Motion?
I'm abstaining from this one.
Okay. So is it unanimous with 2 abstentions?
Okay. The next one under the noise code is for Wise Espresso Bar Corp. at 3120 Coney Island Avenue in Brooklyn. This location has been cited for loud noise from kitchen exhaust on 3 occasions, and due to the repeated violations and continuing failure to come into compliance, DEP is asking the board to issue an order to cease and desist.
Question? Motion? It's unanimous with 1 abstention.
And the last one under the noise code is for, corporate name is Kiki's Plan A Group LLC, which does business as Kiki's, a restaurant, at 130 Division Street in Manhattan. They have been cited on 4 occasions for loud noise from the kitchen exhaust at the restaurant. And again, due to the continuing failure to come into compliance, the department is asking the board to issue an order to cease and desist.
Question? Motion? Again, I believe it's unanimous with 1 abstention.
And finally, under the sewer code, DEP is requesting 2 orders to cease and desist. The first one, which is being brought back from the May meeting, is for Saipan Restaurant at 702 Amsterdam Avenue in Manhattan. They have been repeatedly ordered and issued summonses for failing to install and maintain, grease interceptors for a variety of sinks and drains at this location. The notices of violation have been adjudicated against them. They were ordered to appear for a mandatory compliance meeting in March, which they failed to appear for. And due to the continuing failure to install the grease traps as required, DEP is asking the board to issue an order to cease and desist.
Question? Motion? It's unanimous with, again, DEP abstaining.
And the last one, which is new for this meeting, is Good Vision Taste at 2007 Emmons Avenue in Brooklyn. They have been ordered to do two things and have been cited for not doing them. One is to install and maintain grease traps for the floor drains, and the other thing is to hire a BIC licensed waste hauler to come at least once a month to clean the existing grease traps. They do have some. They're required to install more. But the ones that they have been found repeatedly to be overloaded with grease. Again, a series of summonses and orders have been issued, and they have failed to comply, and in fact have apparently defaulted on most, if not all, of the summonses. They were ordered to attend a mandatory compliance meeting in February, which they did not attend, and based on the continuing failure to comply, DEP is asking the board to issue an order to cease and desist.
Motion? Unanimous with one abstention.
All right, thank you.
Thank you. We'll now have a report on preceding reports.
Good morning, I'm Kelly Corso, Assistant Director of Adjudications. We have 66 preceding reports for this board. 29 of these are discontinuances. These are cases where the respondent did not appear for a hearing, and DEP is recommending the C&D proceedings be discontinued based on a review of records or an inspection showing that the respondent is coming to compliance, that the respondent still owns the premises, or that the premises is being demolished. Of the discontinuances, 3 of them are sewer cases, 15 are backflow cases, 9 are air code cases, and 2 are noise code cases. So that's 29 of the 66 for today. The remaining 37 cases, the respondents did appear for hearings for these. Out of the remaining 37, 34 of the cases were either backflow or air code cases. 27 of those involve backflow violations, and 7 involve air code violations. In all of these 34 backflow and air code cases, the hearing officer recommended no sealing or other action be taken based on the respondent's evidence of compliance that was presented at the hearings. And the remaining 3 cases are noise code cases. In 2 of these cases, the respondents provided evidence of work that had been done to bring the cited equipment into compliance. Based on that evidence, the hearing officers recommend no sealing or other action, provided that DEP's reinspection and further reinspection for a period of 180 days show no violation. In the final case, the final noise code case, the hearing officer recommended sealing of the violating equipment. The respondent in this case is Prime 135 New York City LLC. This case began back in January 2015 when the respondent received a summons for noise from its kitchen exhaust equipment. This kitchen exhaust equipment is located at its restaurant, which is at 135 7th Avenue South in Manhattan. Since no one appeared for the respondent at the hearing in March of 2015, the case went into default. The default order imposed a penalty and order compliance forthwith. The respondent did not comply with the order, and DEP issued subsequent summonses for the same equipment in March and June of 2015, and the respondent defaulted on both of those. DEP issued a final summons in October 2015. A representative for the respondent did appear for a hearing and stated that the exhaust stand was going to be relocated to comply with the air code. The summons was sustained and the hearing officer ordered compliance forthwith. However, a subsequent inspection by DEP in October 2015 showed the respondent still not complied. So on January 28, 2016, the board approved a cease and desist order in this case. At the initial pre-sealing hearing on this case in February 2016 and in each of the subsequent pre-sealing hearings in March, April, and May of 2016, including the last hearing, which was on May 17th, the respondent's representative did not provide any evidence that the respondent had attempted to come into compliance with the noise code. Based on the failure to present any evidence that it has attempted to comply with the noise code, the hearing officer recommends that the respondent's kitchen equipment be sealed immediately.
Any questions? Motion? It's unanimous. Thank you. Is there a motion to go into executive session to review judicial matters? Unanimous, thank you. And we'll adjourn for a moment as we ask members of the public who are not part of ECB or OATH to please wait outside. We're now back in public session, and we have had reports from staff as to existing judicial cases regarding the Environmental Control Board and report on the appeals panel recommendations on appeals. Is there a motion to accept the panel recommendation? And it's unanimous. Before we wrap up today's meeting, I want to acknowledge and thank Daniel Albano, who's here today. He's, I believe, your service for the city ends tomorrow?
That's correct.
After what, 45 years or something?
No, not quite that many. 33 and a half, almost 34 years when I'll finally retire. Matt Smith from my office is going to be taking my place. Matt's an attorney with the legal bureau. Matt's, I think, has got over 20 years with the police department, right? 19. 19, close enough.
Oh, you don't look that old. You don't look that old.
Oh, thanks. I feel that old. I would like to thank everybody. This has been a great experience. I've grown as an attorney. I've learned from everybody in the room. I always compliment the writers on the documents that are presented to us. It's just the writing is fantastic, makes some very dry subjects oftentimes interesting, and it's been a real great experience. So I'd like to thank everybody for that. I really enjoyed it.
Thank you.
Thank you.
How long have you represented the police commissioner here?
About 10 years, at least 10 years.
Is that all? Thank you very much, and I hope you enjoy whatever you're going to be doing on Saturday.
And I'm going to be playing golf on Saturday.
Thank you. Is there a motion to adjourn? We are adjourned.
My apologies for the emergency. No, no, I just wasn't feeling